Hello all, welcome to another lecture of Introduction to Intellectual Property. In our previous lectures, we have gone through certain important types of intellectual properties including copyright, patent, trademark, industrial designs. In our last lecture, we went ahead and saw certain important IPs which are not very commercially exploited but are important from societal point of view as well, which are the geographical indications, trade secrets, biodiversity, and semiconductor integrated circuit layout designs. Now, in our today's session, we will be going through another concept of, though not very much related directly with IPR, but it does play an important role when you talk about protection of intellectual property rights, especially property rights such as trademark and copyright. That is known as unfair competition. Now, the word unfair competition is comprised of two important legal terms. One is known as unfair, and another is competition, which is not an illegal term under the legal sphere. Competition is something which must be healthy, which is promoted, which is encouraged, and which, if taken in a fair manner and in a fair dealing manner, is not prohibited not only under Indian laws but under the laws throughout the world. But the word unfair here gets some connotation because that is something which is not permitted in India. Now, unfair competition is one such type of a word, or it is such a business practice which is deceptive or which is wrongful, and that is economically harming the other competitors in the market. Unfair competition per se is not defined under any intellectual property rights laws, but is one such word which is defined under the Competition Act of India. This word unfair competition has been also analyzed and interpreted by the various courts in India to try and understand whether a particular business practice will be considered to be unfair or not. This being a very hypothetical word, or I would say that this being a very subjective word, it depends upon case to case basis whether such activity will comprise as an unfair trade practice or an unfair competition or not. In simple terms, unfair competition is such a practice, such a wrongful or deceptive business practice which economically harms either the consumers or the other competitors, that is, the other business entities. To give you a small example, let's say for there is an advertisement which we all see most of the times in our on our television. Let's say there is a Pepsodent advertisement, Pepsodent being the toothpaste. Let's say Pepsodent company is trying to advertise its brand on a television advertisement. It definitely will try and compare its toothpaste with some other company's toothpaste just to try and portray to the consumers as to how our toothpaste is better than the other competitor's toothpaste. Many a times we see that the Pepsodent company, whenever it is advertising, when it is comparing with other toothpaste, it will not have the name of that other toothpaste on the brand, on the box of that other brand. It will just show a box, it will compare on its screen, it will show a box of red and white color. Now, a smart consumer definitely understands that either that toothpaste is a well recognized Colgate toothpaste, or it might be also Dabur toothpaste in certain cases. The red and white color itself combination denotes that it is associated with Colgate toothpaste, but Pepsodent is not mentioning the name Colgate anywhere in its advertisement. Not when it is vocally advertising it, neither is it mentioning it on the screen. Such type of competition becomes a fair competition, because when you are trying to compare yourself or your brand with some other brand, but you are not mentioning other brand's name or other company's name, the courts might consider it to be a fair competition. However, imagine in the same scenario if Pepsodent is trying to compare its product with Colgate, and now in its commercial it has mentioned the name of Colgate on its advertisement when it's comparing its product with the other party's product, then in that case such type of advertisement will become a practice which is considered to be unfair competition. Here you are trying to bring down the goodwill of Colgate, which is a registered trademark. So even though unfair competition is not specifically mentioned in the IP laws, but it has got some sort of comparison, or it has got some sort of importance when you talk about infringement of intellectual property rights. Another example is, let's say for I am selling certain copies, I am selling certain pirated copies of a recently published movie on the streets of Pune. In that case, I am not only infringing copyright, but I am entering into unfair competition, because now a person who is able to get the movie copy at 50 rupees, why will he go to the shop and purchase the same movie copy at 500 rupees? That is something wherein my business practice of infringement of a copyright is trying to bring down the profit of that company. That is considered to be unfair competition. Or misappropriation of trade secrets, or false representation of products or services, or false advertising. False representation of products or services is very common throughout the world. Under the trademark, it is also known as counterfeited goods, meaning that the company's products are so deceptive, or they are so similar to a well established trademark, or very well sold, or very well high sold products in the market, that a consumer gets deceptive, gets confused as to which is the original product, and ultimately goes on purchasing the product which is not an original product, because the price of that product might be lesser. Such type of business practices are also considered to be unfair competition. The word may not be used under IPR laws, but such practices are considered to be infringement of the individual IP laws. Generally, two approaches are adopted to prevent such IPR abuse. One is compulsory licensing, wherein the state, that means the government, indulges into taking away the rights of that person, the exclusive rights of that person, by entering into a contract. Such type of licensing involves transferring of certain rights, maybe the rights related to marketing, selling, to another party who is a legal entity. Likewise, parallel imports, wherein the goods are brought into the country without authorization of that IP holder, after those goods were placed legitimately into the market elsewhere. Let's say Disney products. Now Disney, let's say a Mickey Mouse is printed on the t-shirt, and it is sold by Walt Disney in US. Later on, some local manufacturer from Pakistan tries to bring the same product, imports the same products in Pakistan, and tries selling it, counterfeits it, manufactures the product same to same but at a very low cost, and tries selling it as the Walt Disney product. Such type of sale will be considered to be parallel import, and it will be considered to be unfair competition. When you try and relate unfair competition and IPR, there are few things which are very much similar, but few things are quite contrasting, because the ideologies or the logic upon which these two systems have been based are altogether different. When IPR tries to strike a balance between the rights of the owner and the social interest, to make sure that whatever is the right granted to the IP holder, the person is not exploiting it, but at the same time that invention or that creation or that work is used for some societal benefit. But whereas when you talk about unfair competition, this law itself is based upon the logic, wherein an efficient mechanism is put forth to counter the anti-competitive agreements regulating mergers and acquisitions. So in this case, more of a commercial outlook or a commercial approach is taken rather than the social interest. In case of unfair competition ideology, it restricts the use of dominant position, meaning that there cannot be any monopoly in the market. Monopoly means a single seller who is having a dominant position in the market, wherein the buyer or the consumer is not having any other option but to go and purchase the goods from that monopolist. Such type of ideologies are not permitted under the unfair competition. But when you talk about the IPR regime, as we have already discussed earlier as well, that under the IPR laws, an exclusive right is given to the holder of that IPR for commercial exploitation, wherein you are giving one person exclusive rights to deal with that product. Though it is not a monopoly, but yes, legally you are trying to grant tremendous powers to that holder under the IPR regime. In case of unfair competition, it controls competitiveness in the market to make sure that the consumers and the sellers are getting equal opportunity and equal access to the products. Whereas under IPR, it boosts the spirit of the inventor by granting certain exclusive incentives, wherein it is trying to show that you should not be one of the competitors, you should stand out of the competition, and then only you will get certain exclusive rights. You invent something, we will grant you patent for that. You create certain original literary work, we will grant you copyright for that. You create some novel design, original design, we will grant you design rights for that. That is what IPR regime promotes. In case of unfair competition, it is considered to be one of the aims of competition policy to not promote unfair competition. But under IPR laws, providing a chance for technological innovation, which in turn creates more products and results in dynamic growth of the product, is the logic under the IPR regime. So when you talk about unfair competition and IPR, they have got altogether different ideologies or approaches, but the IPR laws in India and throughout the world also make sure that unfair competition is not practiced by violating the IPR rights of the holders. So keeping in mind the IPR rights granted to the holder, the exclusive rights granted to the holder, unfair competition should also not be promoted. They are trying to make a good balance between these two different types of ideologies. So this is what unfair competition is all about. Now what we will do is that we will just go through a quick revision with respect to all the IPs which we have studied in different sessions, so that in one particular session you understand the IPs more in detail. We had started with copyright as the first intellectual property right, wherein we said that copyright is a legal term which is used to describe the sort of rights which are granted to the creators of literary work or computer programs, database, musical work or films, artistic work, dramatic work or literary work, advertisements. Likewise, copyright in India is protected under the Copyright Act 1957 if the term of protection for a copyright is lifetime of the author plus 60 years after his death. Copyright there is no need to mandatorily register copyright. You get copyright upon its creation. So even if a person does not register his work under the Copyright Act, he will still be granted the protection. However, the burden of proving the originality of the work is upon the holder. But in case the person registers his work, then the burden of proof shifts on the other party, that means the infringer. A registered copyright work is entitled to have a mark as an encircled C. You must have seen it in many places on many works. There is a C and it is encircled. Such is the wording or a symbol which can be applied to the work which is registered under the Copyright Act. Likewise, the next concept which we studied was that of the related rights or neighboring rights. We said that they are granted to people who are not basically the creators of or authors of the work, but they assist or they help these authors and creators to make such work available to the public at large. Generally, the three categories are recognized under the Copyright Act, that is, the performers or producers of sound recording and the broadcasting organizations. The next type of IP which we studied was the patent. Patent, one of the most commercially exploited intellectual property right, which says that it is an exclusive right which is granted for an invention which is a product or a process which will provide a new way of doing something or offers a technical solution to a problem. The generally what are patented are medicines or machinery or equipments or such processes which have got some commercial value in the market. Under the Indian Patent Act 1970, the term of protection is 20 years from the date of application of patent. Likewise, you cannot obtain patent automatically, unlike copyright. If you have to get the exclusive rights with respect to patentability, you have to apply it to the registrar and prove that your invention is satisfying the conditions of patentable subject matter which are mentioned under section 3 and 4, and they are novel. It also involves an inventive step and it is capable of industrial application. These four are the most important points with respect to proving the patentability in India. The next IPR which we discussed was the industrial design. The industrial design, the name itself suggests that the design will be judged solely by eye and not by its utility. So if a product is having a specific shape or configuration or a pattern or color which is applied to that article, be it in 2D form or 3-dimensional form, and this particular thing is applied by some industrial process and it is judged solely by eye, it has got an aesthetic value to it, then the design right might be granted under the Indian Design Act 2000 for a period of 10 years, which can be renewed for a further period of 5 years. Likewise, the next IPR was a trademark. Trademark, the name again suggests that it is a mark, it is a symbol, name, color, which is identity of a product or identity of a company altogether. It can be a phrase or a symbol or an insignia or a specific product has got certain symbol upon it. The Trademark Act in India 1999 grants protection to registered trademarks for a period of 10 years, which can be renewed for a further period of 10 years. So, concluding that trademarks can be renewed for 10 years altogether. So, the protection per se which is granted to trademarks is perpetual protection. Likewise, the trademark should be distinguishable from other registered trademarks or other well-known trademarks. The other type of IPs which we studied was geographical indications. In India, we have got the Geographical Indication of Goods Registration and Protection Act 1999, which grants protection to the registered geographical indications for a period of 10 years, which can be renewed from 10 years altogether. So again, it becomes perpetual. Geographical indication typically means that it is a tag, it is an identity which is granted to a particular product which originates from a specific geographical area. For example, basmati rice, or for example, Mysore silk, or Nagpuri oranges, or Alfonso mangoes. They are identified, they are recognized, they are marketed, and they are well known because of the region from where they have been associated. Solapuri chadars or Kolhapuri chappals. And that is why, to protect the indigenous people, to protect their traditional knowledge, such type of intellectual property right is granted under the 1999 legislation. Another important IP which we discussed was the trade secret. As we said, it does not in India we don't have any specific legislation to protect trade secrets. However, under the commercial laws like the Contract Act, or be it the copyright law, or the principles of equity and natural justice, common law action for breach of confidence, and in case of electronic trade secrets, section 72 of the IT Act 2000, protection is granted. Trade secret basically comprises of any practice or formula or a process or a design or a pattern which has got an economic value to that product or to that company, and that company does not want to disclose that information to the public. Might be because of the fear that someone might steal it, and there might be a competition which they would not want it. The classic example is that of the Coca-Cola drink, The formula of Coca-Cola drink is a trade secret, and nobody knows about the exact ingredients in that Coca-Cola drink except for few people under the brand name of Coca-Cola. Likewise, the next type of IP was the biological diversity. The 2002 Biological Diversity Act promoted the protection and accessibility related to biodiversity in India, wherein the biodiversity, which generally comprises of all living organisms in the natural habitat, when they are used for some commercial purposes, for research purposes, there are certain genetic resources amongst them which are modified, for example BT cotton or BT brinjal, and their varieties, plant varieties, microorganisms or genetically modified or organisms, or such organisms which are in their natural habitat but are used for some specific invention or creation or modification, be it in healthcare, be it in any other type of industry like textile industry, healthcare. Such type of IPRs are granted under the 2002 Act. Likewise, this act also goes on providing about sharing of genetic resources under the access benefit sharing provisions and genetic resources and biotechnology related provisions. And the last IP which we discussed was semiconductor integrated circuits layout designs under the 2000 Act, which grants registration for a period of 10 years. Likewise, semiconductor integrated circuits are the quintessential factors under any mechanical processes. The layout design of transistors are the most important component under any technical or semiconductor chips, be it computer chips or be it integrated circuits, which are basically the building blocks for any patentable product. So in India, we have got protection for such layout designs for a period of 10 years altogether. So these are the main and the most important IPs which I thought of discussing with you all. And these IPs are not only commercially exploited, but these IPs also grant certain good protection to the inventors, to the creators, and to the holders of that intellectual property. With this basic knowledge of intellectual property rights and the types of intellectual property rights, in our forthcoming sessions we will be discussing each IP in detail to understand its registration, its infringement, the defenses available for infringement. We will also go through the Information Technology Act, the cyber crimes, and the semiconductor chips. So we will try and understand the legal as well as certain technical scenarios. So before we move on with the next sessions, I would request you all to quickly go through all these types of intellectual property rights, get an idea of it, get a grasp on the logic and the concepts. You can refer to this PPT or just Google it or use some any other electronic medium to get more knowledge about these IPs, so that in our forthcoming sessions, whenever we will be discussing these IPs in detail, you will be able to grasp quickly and you will be able to understand the concepts very much in detail. So for now, thank you so much, and I will again have a word with you all in our next session. Thank you so much.